Okay, so for those of you don't go anywhere who are joining us, we have our next panel, and it's on as I think it was Melissa or Paula referenced. It's called "Secrets Unsealed: The Ins and Outs of Accessing Court Documents." We have a great panel that has a wide range of opinions on this. I will say, I come from a plaintiff litigator point of view, and I frequently wanted to have documents and trials and hearings in the open, and sometimes documents and trials and hearings were not necessarily agreed to or wanted by my opponents. So I want to thank you all. I'm going to let you each introduce yourself and take it from here. Thank you very much.
Great. I'm Heather Murray. I'm with the Cornell Law School First Amendment Clinic, and a portion of my docket each year focuses on representing journalists seeking to unseal state and federal court records.
I'm Sharon Dietrich. I'm with Community Legal Services in Philadelphia. I'm the litigation director there. My specialty is criminal records, and vis-a-vis this conversation, sealing and expunging records, particularly through a relatively new process called Clean Slate, which involves mass sealing of records.
Oh, Janon, we can't hear you.
We can't. You need to unmute.
There you go. Apologies. Yeah, my name is Janon Fisher. I'm a court reporter for Newsday in Long Island. I cover the Nassau County courts, the district court. I also cover the Southern District of New York in Manhattan, and Manhattan criminal courts as well.
Great. So we'll start today's discussion with a quick overview of access to court records, starting with the presumption that our nation's courts and its records are generally open to the public. But if every hearing and record was open to the public, there would be no need for webinars like this, and lawyers like me would have a lot more time on their hands. We'll then talk about what records are generally open and closed, including a primer by Sharon, perhaps the foremost expert on Pennsylvania's Clean Slate law on sealing of criminal records. And then Janon will discuss what to do in the moment when you're confronted with a sealing issue. Let's start with first principles on court access. What happens in our nation's courts is presumptively open to public scrutiny, with judges issuing public decisions after public arguments, largely based on public court records. And while court records by and large should be open to the public, too often when journalists contact me for help, documents have been sealed without the parties having met the heavy burden under the law to support sealing, and without the court issuing particularized findings on the record, as it should, that closure was essential here to prevent serious harms identified by the parties. Just a week ago, Federal Judge Wolson in the Eastern District of Pennsylvania underscored this serious issue in another panel on court access at the Berkeley Judicial Institute, where he said that parties in his courtroom should not expect him to rubber stamp requests to seal. He said that courts cannot permit parties to yada, yada, yada their way to showing of harm to seal documents. And the gist of what he was saying is that while yada, yada, yada-ing may work well in an episode of Seinfeld, it has no place in our courts. He said, you've got to be specific in telling me what the harm is if you're going to claim harm to sealed documents. Now, serious harms that courts find at times justify sealing include national security threats, disclosure of trade secrets, impeding the fair trial rights of criminal defendants, privacy rights of parties or third parties, or privileged information. And Judge Wolson's interpretation is spot on in my view. Case law in federal and state courts interpret the U.S. Constitution, and here in Pennsylvania, the state constitution, as granting the public and the press a presumptive right of access to both civil and criminal records. Courts throughout the country have also recognized a common law right of access that predates the Constitution. And court records may only be sealed from public view by statute or by a court order based on particularized individual findings on the record demonstrating that a high bar for sealing has been met. Now, If you are in a courtroom, you don't agree with the sealing decision as it's happening, you have a number of options, which Janon will discuss in further detail later on in the panel. I'll run through briefly what those are now. You can object in real time by asking the court's permission to speak, stating that records like these are generally open to the public and requesting that the records not be sealed without a hearing where you have your lawyer present. And when this isn't possible, sometimes it isn't, or it isn't successful, you can then object in writing after the fact. Sometimes a short letter with no intervention by a lawyer is enough to shake loose the documents. For example, several years ago, an Alabama journalist sent a 2-sentence letter to a family court judge requesting unsealing that resulted in a hearing 9 days later, unsealing the records. And the letter was really simple, and I quote, he said, "Court records in divorce cases are typically public documents," he wrote. And we believe, in light of recent events involving U.S. District Judge Mark Everett Fuller and the criminal charges he faces, it's in the public's interest that these documents in this court file again be open to public inspection. He did that without a lawyer. The third option, as George W. Bush would say, the nuclear option, is to get a lawyer involved, like me, to file a motion to intervene in the proceeding and to seek unsealing. There are pro bono lawyers at clinics like mine. Through the Reporters Committee for Freedom of the Press, you just saw, for those of you on the last panel, you saw Paula Knudsen-Burke. Through your state news associations can connect you to lawyers, through Projourn and Lawyers for Reporters. And what that would typically look like is a lawyer will prepare a motion to intervene and unseal the court records. And then once that is filed, parties are given an opportunity to oppose the motion. Now, if there's no opposition, the court will oftentimes just unseal the records. If there is an objection, the court may hold a hearing and rule on the dispute. That could take a matter of months. And then there could be an appeal after that. So there are times, and I've had this happen recently in a case in New York, where it took 2 years from the time at a family court hearing where the journalist was locked out improperly from the hearing to when he actually got access to the transcript of the hearing. So that's something to keep in mind, is that when you're going to court to litigate it, you might not get the records immediately. I'll touch briefly now on what records are generally open that you should have access to, and some that are generally closed. It varies based on the jurisdiction, but these are sort of general principles for you. You should have access to the docket sheet. There was a scandal in Connecticut over 2 decades ago after the Hartford Courant learned that thousands of state court cases had been sealed. Some of them were divorce, paternity, and other cases, purportedly at the request of judges and celebrities and wealthy CEOs there. And it really threatened to create a 2-tier system of justice, where those with connections could have their messy divorce and paternity cases heard in private, and the rest of us were having them heard in public. And really, without access to the docket sheets, the ability of the public and the press to attend civil and criminal cases would be merely theoretical, because the docket sheet is really an index to the judicial proceeding. You oftentimes won't even know if a hearing is set if you don't have access to that docket sheet. Search warrants is another thing, and there's oftentimes a waiting period to get access to those. In Pennsylvania, I believe it's 72 hours. Pleadings, so the complaint and the answer in a case that sort of initiates the case. Courthouse News Service has litigated around the country over this issue of timely access to complaints, because in many jurisdictions, courts will take several hours or days to process the complaints, and they've successfully litigated and said, no, you shouldn't, the First Amendment right of access is not fulsome if we're not getting timely access to these records, and in many jurisdictions have have forced the courts to release the records as soon as they get them and not after a period of processing. You should also have access generally to pretrial motions and records, to trial records, to sentencing records, to settlement agreements. I will say we've litigated in partnership with the Reporters Committee several times recently over access to wrongful death settlement agreements. The case for making these public is very clear. There are very few cases nowadays that make it to trial. And if you don't have an open trial followed by a court decision, and if you also don't have a public settlement agreement, the public is really left in the dark as to how cases are ultimately being resolved. And then appellate records, you also should generally have access to. I'll touch briefly on some records that are generally closed. Grand jury records, juvenile dependency and delinquency records, medical and psychological records, adoption records, and discovery materials. I'll touch briefly on discovery materials because they're handled a little differently from other court records. Oftentimes discovery materials are just exchanged between the parties, and then sometimes they're filed with the court, or later on they're used at trial. When they're filed with court or used at trial, you then get a First Amendment right of access to these. There's otherwise, if they're just exchanged between the parties, there's generally no First Amendment right of access. But if there's a litigant that wants to share discovery with you as a journalist, you have a First Amendment right to receive those records. So I'll highlight that. And then I'll also note that what oftentimes gets in the way of discovery being readily distributed by the parties is that the parties will either privately agree to keep documents confidential, or they'll request that the court issue a protective order that forbids the parties from disclosing certain information. And parties are supposed to demonstrate good cause for a protective order by demonstrating that disclosure will cause a clearly defined and serious injury. But courts seemingly do rubber stamp these requests oftentimes. So I'll flag that. Courts do retain the right after they put a protective order in place to modify it or entirely lift a protective order at a later date. And journalists have successfully intervened and modified protective orders at a later date. I'm now going to hand it over to Sharon.
Thanks, Heather. Hello, everyone. I am here today to talk about one of the big exceptions to the general openness of court documents, and that is criminal record, what we call in our world, in the legal aid world, record clearing, also known as expungement, also known as sealing. Those words can have different connotations. So I'm going to basically talk about three things today. First is to give you a brief history of criminal record clearing, because I think it'll help you understand better why we are where we are with this topic today. I'm going to get a little bit more into defining what criminal record clearing is more specifically, because I think that'll be helpful to you. And finally, I want to talk about variation by state, which is actually quite all over the place. So first of all, criminal record clearing has been in the news a whole lot more, maybe in the last decade or so, but it's really not a new concept whatsoever, to the extent that pardons, the executive forgiving a criminal case, go all the way back to the kings of England and came to the United States with the colonists and have existed since that time. So the history is extremely long. But even the more common sorts of criminal record clearing, expungements, go back to the 1940s. So this is not something that has just developed. However, I will say that the use and the availability of these remedies have, over the course of time, increased dramatically, even over the last 10 years or so. And there were a confluence of events in the 1980s and 90s that really made having a criminal record more damaging, which is part of why we are now where we are. First of all, there was the war on drugs, which resulted in criminalization of many more people, to the extent where now, believe it or not, there is not a known number of people in the United States with a criminal record. But the best estimate is that it's in the area of 1 in 3 to 1 in 4 American adults has a criminal record, which is kind of astonishing. So this is not a fringe problem. When I first got into this work 30 years ago, it was seen as a fringe problem. It is not, and that's pretty well known at this point. The war on drugs had a lot to do with that. And then, of course, there was 9/11 and concerns about not only terrorism, but other criminal activities heightened around that, including lots of civil laws that were passed to prevent people with certain records, often very broadly, from working in many different fields. And then the third thing that has made a big difference is technology. Before technology, it was not easy to get a background check on someone. You could walk into a courthouse, or you could hire someone who would walk into a courthouse and check a record for you, but it wasn't like digitized and really available, and certainly wasn't cheap. Now it is all of those things, and that has led to the development of a huge background screening industry, a multi-billion-dollar industry, where employers and landlords and lots of others can get background checks very cheaply and very quickly, and I might add, often of a very badly done preparation, often which are wrong. And so when all these things come together, former defendants found themselves in a much different posture than they used to be. Now they can't get jobs. They can't get housing, access to education. All of those things became a real big deal starting in about the 1990s or so, and accelerating over the 2000s. I had a client once who told me that it was easier for him to get a job when he came out of prison in the 1970s than it was in the 1990s because of these things having happened. So, so former defendants found themselves in many cases ostracized from participation in society. The General Assemblies around the country noticed. And so state legislatures in the past decade or so have really expanded access to criminal record clearing. And that's both in terms of who's eligible to get their cases cleared and the process by which cases can be cleared. I guess the last thing I'll say about this before I get into the more specifics is there is a reason that record clearing has been such a popular remedy for overcriminalization and for the barriers that people with records have. And that is because it provides very broad relief to the people who get it. And my clients here in Philadelphia, legal aid clients, know that. They don't come here usually saying, an employer turned down my application and I want to sue that employer. They come here and say, I want my record cleared. I want it expunged, is the thing they usually ask for. And the reason for that is that it does work not only for them to get a job, but also for them to get the housing and the education and access to many other things. So the broad nature of this is part of the reason that the legislatures, including here in Pennsylvania, have expanded the remedy. And the remedy also often tracks known research on whether a person presents ongoing risk of criminal behavior or not. There is at this point very strong research that says that if you desist from crime for 4 to 7 years, depending on the nature of the offense, then you present no more risk of committing that crime again than anybody else in the general public. And so these expungement and sealing laws often pretty much trace that research. Okay, so that's the background and why we need this and why we have it. So what is it exactly, this record clearing thing? Well, there are basically two types. First of all, there can be complete destruction of records. In Pennsylvania, we call that expungement. And when I say complete destruction, I mean court records being taken to the shredder. I mean data being eliminated. So that is something that is a complete remedy. But Pennsylvania having expungement of that nature is kind of an outlier. Most states do not completely destroy records. Some do, but most do not. What is more common, and we have it here in Pennsylvania as well as elsewhere, is what in Pennsylvania is called sealing. Actually, the formal name is limited access, but people colloquially talk about it as sealing. And that means that the records are not destroyed. They're not taken to the shredder. The data is not eliminated from databases, but the access to that information is limited to those who by statute are given access, law enforcement being the most common. Press usually does not get access. And to the extent there's any exception, and we don't really have this exception in Pennsylvania, it is that you might not be able to get access to individual records, but you might be able to get bulk data for purposes of doing journalistic work. So the data is then anonymized, and in some places you can get access. There's a growing trend in that direction after, especially researchers have said, look, we can't do our research when these records are not available to us. And I think the press have made similar arguments. And so that has been a move to get some of the sealed data available. However, like I said, access to a sealed case and on an individual basis is not likely to be available to you. Now, there are three types of processes by which an individual, one of my clients, might get their record cleared. The first is, and this was the traditional process, you would have to file a petition. So you would get a lawyer, that lawyer would write up papers, the papers would be filed with the court, there'd be a court hearing, and then if granted, lots of paper would be pushed around, and finally your record would be expunged or sealed. And as you might imagine, that all sounds good, but for an individual to actually access that, there are a lot of obstacles. First of all, do they even know they have a right? Can they find a lawyer? Can they afford said lawyer? Can they afford the filing fee? Can they afford to wait for what could be months for a hearing to be scheduled? So petitions have been with us for a long time. They will continue to be with us. But the new trend is towards what we have branded clean slate, which essentially is sealing of records by automation. And I'm happy to say that we here in Pennsylvania were the first ones to think of this idea and to enact it into law and to implement it. And so basically, this is very different than the petition process. Essentially, the way it works is that the legislature has said, these crimes can be sealed by automation after this period of time. So the rules are very discreetly written out. And then it is done completely by technology. And I mean completely by technology. So the computer every month identifies the cases that are eligible to be sealed. It transmits, it prepares and transmits an order to the local judges to sign off on, but they are not looking at that order and really deciding it case by case. I can tell you that because that would be humanly impossible given the numbers that are presented. So the order is executed, and then the computer basically does its work to seal up the cases. So this is being done by algorithm. This is being done in scale to the extent that in Pennsylvania, we currently have over 46 million cases that have been totally or partially sealed. The third type of process, which other states do more than we do, is what I would call automatic as opposed to automated. So automated obviously deals with technology use. Automatic has often the connotation of the person does not have to take access to get their record cleared, but somebody's doing something by hand. So for instance, my understanding is that in New York State for a long time, they have, after a case is, excuse me, after a criminal case is dropped, they will, I'm not sure if it's seal or expunge because I don't follow New York law that closely, but the clerk's office will take the steps needed to clear that record for that person. So it's being done on a case-by-case basis, not by automation, but the individual doesn't have to take action. Finally, there are wide varieties by state. First of all, the names, what is expungement, is very different depending by the state. So in Pennsylvania, expungement is that process of completely destroying information. Other states use what we essentially call sealing and call it expungement. So be careful with that if you're doing multi-state reporting or you're not in Pennsylvania. The second thing that has wide variety is the eligibility criteria. Pennsylvania by far has the most records sealed of any state, thanks to Clean Slate. But our eligibility criteria run fairly far behind what a lot of other states do. It is harder, you wait longer, a more limited number of cases are sealed. We recently passed our third version of our Clean Slate law, which for the first time allows felonies, some felonies to be sealed after 10 years. Drug felonies can be sealed by automation. Property felonies like theft can be sealed by petition. But a lot of states go way further than that, both in terms of how long you have to wait. They make it earlier. They make it for a broader range of crimes. And the final thing is the development of Clean Slate. As I mentioned, we were the first in Pennsylvania to have this. I'm very pleased to say that everyone here pulled together, and it's been a very popular law. As a result, many other states have been adopting Clean Slate laws. So there are now 12 states since we passed ours in 2018 that have passed Clean Slate laws to do something similar to what we do. Most of them are not yet implementing it. As I understand it, California and Michigan, I believe, are the two states that have fully implemented besides Pennsylvania. Other states that are kind of in progress are Connecticut and Utah. They've started, but they haven't completed. But many more bills are in play. If you're in a state other than one of these 12, your state's probably looking at Clean Slate because everybody recognizes that this is a way of helping people with a really bad problem and doing it at scale. So with that, I will stop and throw it back to Heather. I think you're kind of kicking off step 3 here.
Okay. I had actually covered a little bit of what I was going to already, so I'll kick it over. To Janon to talk about his experience.
Okay, thank you, Heather. So yeah, I'm not a lawyer. I cover the courts. I've covered the courts for about, on and off for 30 years as an editor and a reporter. Most of the time you can walk into a courtroom and there's not a problem. You can listen to the testimony and there's no issue there. You can walk into the clerk's office and you can ask for a file and see that it's, but when it comes to, the really good stuff, that's when judges and lawyers get, prosecutors, defense attorneys, and plaintiff and defense lawyers get a little bit touchy about what comes out. So it's the really sensitive stuff, obviously, that's the problem. Sharon said that the definitions are important, and for me, what people define as sealing, there's a formal process or the things that are automatically sealed. Like in New York, divorce records are sealed. An acquittal, a criminal case is sealed after the acquittal. But to me, these cases, the things that I can't get access to that should be public, that are not off limits by statute, by my definition, are sealed because I can't get access to them. So I've run into, or I've had discussions, arguments, I guess if you want to call them, with clerks and judges and prosecutors about whether something's sealed or not. By well, it's not sealed. You just can't you just can't get it right now. It's not, I'm not going to give it to you, but I'm not sealing it, which allows them to withhold something from you without going through the formal process. So I guess I could talk a little bit about, what I do and how I confront these issues. I recently covered the Trump trial. I think that's an interesting example of when things are sealed and when things are public. Formally, the jury selection, it was an anonymous jury. That was certain testimony during the voir dire was sealed. I don't think anyone objected to that, and I don't think they would have any luck in getting that stuff unsealed because there was a discussion about whether the jury safety was at issue. So I don't think you could get that. But there are other cases, at one point during the testimony, the judge kicked the entire press corps out of the courtroom and allowed the sort of the entourage of the defendant to stay in the courtroom. In that case, to me that's sealing the courtroom. The judge didn't hold a hearing. There was no process by which we could object, although several of us tried. There was an attorney with Davis Ray Tremaine who stood up and was sort of frog marched out of the courtroom without being able to intervene in the case. I think that there are a lot of cases in which records are sealed in a practical matter, not sealed in an official matter. And I try to tread this line between being annoying and just sort of asserting my rights. It's a public forum. By extension of that public forum, the records in the cases are public. So I started with a sort of limited knowledge of that, and then have slowly educated myself on what the law allows and what it doesn't allow. And from what I found is that there's really no process by which a journalist can access there is a process, but no one really knows what it is. The judges in most jurisdictions have different opinions on what should be public, and some judges in Nassau County understand this is a public record, this is a public forum. You have the right to access these records, and that's not a problem. But other judges, think that's. I had a judge's clerk tell me, she said, I'll have to check on this, but I think the only people that have access to the court file are the attorneys involved in the case, which is obviously wrong, but it's a judge's clerk who's telling me this. It's upsetting to hear that, and it's clearly not true. So what I've run into lately is an issue with access to court exhibits in which a photo or video or a document will be presented in a trial, and having access to that record during the trial. And, most of the time, the judges feel that any sort of intervention, especially by the press, it was only disrupting the case, inserting yourself into the process. They want to have a tight rein on what's happening and how the case is going. They don't want the jury to see. Well, this was the other thing that I found unusual at least in Nassau County, is that a supervisory judge told me that we don't give out court exhibits during the trial. That's just our policy, which is based on nothing that's in any case law. But her reasoning was, we don't want the jury to be Googling during the trial and find these records, find the video. And my argument is, well, they've seen it. If it's entered into evidence, the jury's already seen it, and they feel that in that context it's okay. But if it's in the context of a news article, it's not okay. There's other information. There's stuff that could be excluded from testimony that's in the record, in the article. My argument, of course, is that you've charged the jury, you've instructed them not to look at the internet to read newspaper articles. That's their job. If they violated that oath and they jeopardize their right to be jurors, and that's the issue that you should address, not limiting the First Amendment right to access the trial because you're trying to prevent the jury from Googling the any articles on the trial. Let me see. So I guess that's so I've my advice, or the way I've sort of approached it so far, is to try and always get the clerks on your side. Try to talk to them about what you're covering, help them understand why it's important, because they're really the guardians of these records. So if they agree with what you're doing, they're sort of allies, and they'll give you stuff as they should. But there's no discussion. I had a case where a Nassau County cop was accused of rape, and the clerk did not want to give me the records. She felt that it was sealed. It wasn't public under a New York law. And we had a discussion. I finally got the records, and that's really introduced. That was our introduction and a way for her to sort of see, okay, well, this is, there are public records. There's a reason why they're out there. And sort of, I've discussed with her, why they are, and now she's sort of more on board. But as I said, the judges are really the issue. I've written like Heather mentioned, the two-line letter or the two-line request, where the judge said, well, you've misspelled some things here, and I was dashing it off as quickly as possible. It didn't give me the records, even with that. I had a judge recently ask me for a order to show cause to get records, which I was happy to try and do. I mean, I'm not a lawyer, but I took a shot, and our in-house lawyer said, no, don't do that, because that sets a precedent. These are presumptively public, and if you start to file an order to show cause, then you're basically undermining that presumption of access. The judge is actually asking you for proof of why you should have access to these records.
Janon, can I just jump in for a second
Of
and say,
course, yeah, sure.
I've seen the order to show cause, and you wouldn't know first looking at it that Janon wasn't a lawyer, so he did a good job there. But I'll also note, just to
I've heard a lot of your stuff, Heather.
just to highlight what he's saying there. Asking a journalist to put in an order to show cause is really flipping the burden here. It is not Janon's burden to show why these records should be released. It is the party seeking sealing's burden to show that there's a good reason for that closure. So it is really troubling to see that you were even asked to do that. So I just wanted to flag that for folks, that's not something you should be seeing, and you should consider reaching out to a lawyer if somebody asks you to do that. Janon, I thought it might be helpful also for you to, just for nuts and bolts brass tacks here, when in real time, when you're objecting, are you going to a clerk first? Are you going to the judge? What are you doing?
Yeah, so it depends on the judge, of course, what you're allowed to do. So I usually, we're talking about exhibits in most cases during a trial. So I sort of gingerly go to the court officer and say, I would like to talk to the clerk, or I would like to request the exhibits that were shown today in court testimony. and they relay it's sort of a game of telephone. They sigh deeply and then walk over and tell the clerk that I'm being annoying again, and then there's sort of a back and forth. Well, there is no process. That's what, and I don't want to speak for Pennsylvania. Maybe there is a process in Pennsylvania for accessing during a trial, but then the clerk says, well, let me talk to the judge, or write a note and request, just to request it in writing. And or the judge will say, yeah, I've had the judge say, yeah, this is a presumptively, this is a public record. But this is the other issue in New York, is that the courts rarely keep the records that are presented in trial. They are trial records, they are court records. But most of the time the judge looks over at the prosecutor or the defense and says, I don't have these. It's on a thumb drive, it's a spreadsheet, or it's a video. We don't have the technology to copy this and give him a copy of it. So can you guys just email it to him? Or, that's the best case scenario. Still drives me nuts, because the courts, the integrity of the court exhibit is sort of, there's no chain of custody, that the prosecutor still has it, the defense still has it, and when does it become part of the file? It should be part of the file as soon as it's entered into evidence, but that rarely happens. So, and then it depends on what, sometimes the judge will actually hold a hearing. I had a hearing recently, a police officer who was off duty shot and killed his best friend. And there was some video and other things that I'd asked for, and the judge had a hearing, and they went into the defense. It was the attorney general who handles all police force cases, and defense attorney. They went into the chambers without me, of course. They had a discussion. They came back out, and they had a hearing, in which they said, okay, who objects? They both objected. And they allowed me to make my presentation, and the defense attorney said, well, I feel uncomfortable with these records being released. And the judge said, well, there you go. He feels uncomfortable with these records being released. So I said, well, I don't think that's the balancing test. If the defense attorney feels uncomfortable, it has to be some proof that it would undermine the trial. And so the defense attorney got back up and said, well, if somebody got hold of this and used AI to manipulate the recording, that could, present a false impression of what happened. And the judge said, okay, we'll go with that then. That's what we're going to seal it for that reason. So they wouldn't let me have it during that. The police officer was actually acquitted, and so the records are now sealed. So I don't have access to them.
Yeah, and suggesting that somebody could manipulate through AI at some future point is a purely theoretical suggestion of harm, and should not have carried water there. Janon, when you're making these presentations on the fly, do you have any suggestions for folks on the call of how to do that?
Well, I've written a couple of, I've written that order to show cause, and I've done some research and I feel much more confident now in making an argument. So I would say doing your homework and understanding the latest cases, even if you don't have the latest, but you have a solid case to cite, to say, there's a presumption of openness in these court records that's derived from the First Amendment. This is a public forum. These records were presented in a public forum, and that's by that extension, I should have access to them. So I think that, just being confident, being able to understand the process and what your rights are, because they don't teach this in any journalism school. They certainly, the court newspapers don't understand it. So, there's really, there's very little exposure you get as a journalist to how to do this. And it sort of, to me, during the Trump trial, it was sort of enlightening that when I saw the lawyer that was representing the press in the courtroom at the Trump trial stand up and say, we would like to intervene in this attempt to throw the press out, and he's grabbed by the arm by the court officer and escorted out, like where the how much power or lack thereof you have in these situations. So it's it's very case by case, and I don't think most judges recognize or respect that aspect of the law.
Hi,
I would add,
just, oh, yeah.
I just want to add, I don't think they really teach this aspect in law school either. When I took constitutional law many decades ago, I don't remember any focus on access to court records. There are many aspects of First Amendment, there are many aspects of constitutional law. This is not one. Lawyers understand that they can get protective orders and things like that, but I don't think there's a basic understanding, even in the legal profession, that there is a strong First Amendment presumption of access to court records.
And there is, as you noticed, a wide variety across the 50 states and across, every state has different access laws. Pennsylvania, you cannot record, you cannot bring in cameras. Arizona, totally different. Federal courts, you are not allowed, cameras and recording, but each court also can, and actually this is like a perfect lead into the next session, but each court can establish its own rules and procedures for that trial. And it's up to, and sometimes high profile cases, which is what we will be discussing next time, courts do make sure that there's access because they do understand the importance of it. But you're right. I mean, it is inconsistent based on where you are.
Yeah, and what Sharon said about it not being taught at law school, I'm at a law school. We do teach it in our clinic now, but I think doctrinally that it's still not touched on in constitutional law, for example. So it might be on some of us to ensure that it's getting out. Of course, the First Amendment right of access is not even that old. So it for folks who went to law school, 40 plus years ago, it wouldn't have been covered there because there wasn't a First Amendment right of access until the 80s. So
I would say that, it also varies widely from judge to judge. Some judges are elected, some judges are appointed in New York, and they all go through a sort of a new judge education process with the Office of Court Administration. But I don't know that they focus on this that much, and some of the judges who understand it, will automatically, just it won't be a big deal, and others. I've been brought into the judge's chambers sometimes, and we've had a very heart-to-heart discussion, and that they've decided that we're going to give this to you, but we want you to be very careful with it. And it's sort of like, well, I do what I do with it. I publish it, and I let people read about it. That's how it works.
There was sorry to interrupt you. I know we're sort of running out of time, and there was an interesting question, and I don't know who can answer this, but do you need to get permission to have drawings in the courtroom? I mean, Janon, have you ever had that experience with respect to an artist in the courtroom?
Oh yeah, I mean, many times. I think in New York, anyway, my sense is that judges love court sketch artists. They love to look at the photos. They like to see how they're portrayed. So they love the court sketch artists. They don't like photographers. But I think that it's generally that's not there. In some hearings and sentencing, I've seen them be placed in the jury box so they have better angles. So in New York, I think that once they show up, everybody recognizes what they're doing with their big pads and their pastels and everything, that they understand what they're there for. And I've never seen anybody have a problem with it.
Yeah, what an interesting question. The one time that I covered a case at the U.S. Supreme Court, many years ago before I went to law school, Myra Coleman was actually sitting in the press box, you know, doing her illustrations at the time. So it's allowed there as well. So great.
Okay, so I guess any last minute advice, right, to the journalists? I know, Sharon, there was a question about, I guess about how violent a crime can be. What types of crimes are permitted to be expunged or sealed, and what types of crimes aren't? Could you address that quickly?
Sure. Again, state by state, but generally violent crimes do not tend to be expungable. Sex crimes, same. In Pennsylvania, you can seal a summary offense because it's a misdemeanor, but you cannot seal an aggravated assault, for instance. So most crimes of violence are not able to be sealed.
Great. Debbie, I had a question for you as we were talking about the lack of education of some judges on this point. Is this something that that your organization works on at times, education of judges?
We do provide continuing judicial education for judges. There's different, I'll say different requirements for continuing judicial education, again, which vary state by state. But I know in the next panel, you're going to hear for Pennsylvania, from the AOPC, Stacey Witalik, who does have programs on this topic before, like for new judge school, as Janon said. I mean, in state court, when you become a judge, you have to go to new judge school. And in the federal court system as well, there is, information provided. I think I believe, okay, that there's more information now provided to the judiciary about this topic, since we are now more of a journalistic media, social media, internet society. It used to be different. I know that the last panel I have Judge Roof on, she used to talk about how they used to have a press room in the courthouse where there was like press that was specifically responsible for covering the courthouse. That doesn't happen, unfortunately, because of the financial constraints on journalists and media. And so now it's just a different way of operation and operating. And Jane, it sounds like you have focused on covering court cases, and I would be curious as to, and I know I'm running out of time here because we want to give everybody a break, but I'd be curious as to, over the time, if there hasn't been more of a receptiveness in some fashion to journalists covering the court.
I think it's sort of like a muscle. I think when it doesn't get exercised, it atrophies, and I think that I've seen various. I mean, I was the first regular reporter in Nassau County in 2 years. So when I got there, I found a lot of resistance. It's sort of waned, and I think that's, it's just being underfoot and being there and always asking and letting them know that you want that. I think that helps. I think if they don't know how to do it, if no one ever asks it, they don't have a process for fulfilling those kind of requests.
All right. Well, I want to thank you all for joining us today on this panel. It's great. And each panel is like leading into the next. It's wonderful. We're going to give everybody a 10-minute break to grab lunch or a bathroom break before our next panel, which begins at noon. So thank you all. And please don't hang up on us or whatever. Don't go away. Just take a break and join us back in 10 minutes. Thank you very much.
Thank you.